justice under new leadership finding out or trying to find out why that happened. I'm curious. I know you're a good lawyer. You should be curious too. That's the only point I wanted to make.
Mr. Chairman.
Before you speak.
Yes, sir.
I think I want to clarify what I've been trying to make. So I want to run this markup the way Chairman Durbin did. He asked members to, quote, wait until each nominee is called if they wish to make a comment on a specific nominee, end of quote. He also asked members not to speak on matters that were simply being held over and to wait until a matter was, quote, ripe for consideration to debate. We routinely were afforded the opportunity to speak on nominees that were simply being held over. We were not, I should say. We're not going to have a double standard here. And as I mentioned, for the last 2 years, committee Republicans didn't make Democrats meet just to hold over nominees. Senator Whitehouse.
Thanks, Mr. Chairman. I just wanted to address the letter that three of us sent to you related to a new precedent that this committee seems to be setting. During the hearings, Senators Schiff and Booker and myself asked questions about what transpired in the grand jury that Kash Patel testified in. He was unwilling to disclose any of that, even though Rule 6E very plainly allows for a witness to come out of a grand jury and describe to the entire world what it is that they told the grand jury. He then said, when confronted with that legal fact, that he thought that there was a seal order of some kind that he was under that would prevent him from doing the customary witness disclosure that is commonplace, a commonplace right under 6E. In that regard, we've looked wherever we can. We've asked him where this order is. There is no sign of a seal order that would bear any relationship to his testimony. So there's the very real prospect that he's simply being untruthful about there being a seal order. The further aspect of this is that he asserted his Fifth Amendment privilege not to incriminate himself during the course of these proceedings. That, as a matter of law, requires that he have had a substantial and real risk of criminal prosecution when he made that assertion. So if an incoming FBI director has faced a time when he believed he had a substantial and real risk of criminal prosecution, it seems to me that it's pretty elementary that this committee, acting on his nomination to that office, should have some idea of what the crime would have been. And last, those of us who've practiced law understand that if a witness asserts a Fifth Amendment privilege and then appears in another proceeding, like a civil proceeding, for instance, and does not testify because of that Fifth Amendment privilege, the jury in that case will be instructed by the judge that those jurors are allowed to draw the adverse inference that what he would have testified had he not pled the Fifth would be adverse to his interests, and he could be treated as having testified adversely to his interests, that the facts would be adverse. So if a court, a regular district court in a regular trial, can draw that adverse interest about what is behind a Fifth Amendment assertion, then damn, this committee ought to be able to draw the same adverse interest or have that, adverse inference, or have that adverse inference dispelled by having this individual actually testify about it. If we want to do this in closed session, if we want to do this with some safeguards, all of that is fine, but you spoke very eloquently at the beginning of this, Mr. Chairman, about the importance of precedent, and I just want to mark right now that this is a first-time precedent in which a nominee for a senior law enforcement position in the United States of America has asserted a Fifth Amendment privilege about his own conduct and has testified in front of a grand jury, and the committee is being denied access either to the gravamen of his Fifth Amendment assertion or the content of his grand jury testimony. To me, that is an extremely dangerous and indeed even astonishing precedent.